Did you shoot a 300 blackout into her head, causing her death?
Mr. Griffin, I didn't shoot my wife or my son anytime. Ever.
Alex Murdaugh, he's serving 2 life sentences for the murders of his wife Maggie and his son Paul, and now he's asking South Carolina's High Court to grant him a new trial.
On June the 7th, I wasn't thinking clearly. I don't think I was capable of reason.
But the state is pushing back, saying the now indicted clerk of court's antics during the trial and other claims are not enough to overturn Murdaugh's conviction. I take a closer look. Welcome to Crime Fix. I'm Angenette Levy. Alex Murdaugh is demanding a new trial for the murders of his wife Maggie and son Paul. He readily admits that he's a liar and a cheat and a thief, but he claims he's no murderer. Now, this case took the country by storm. Alex Murdaugh was part of a legal dynasty. He was royalty in South Carolina's Low Country, but prosecutors say Murdaugh's life was a facade and that it was all crumbling in 2021, and he was about to be exposed because of the lawsuit he was facing because of the boat crash that killed Mallory Beach. Paul Murdaugh was driving the family's boat drunk and crashed in February of 2019, killing Mallory and injuring many of his friends. The Murdaughs were facing a massive civil suit, and the state contends that Murdaugh's financial misdeeds were going to be exposed through that suit, and that he was stealing from his clients and his firm to fund his lavish lifestyle, and that he simply couldn't let that happen. So prosecutors argued at trial that Alex Murdaugh shot and killed Paul and Maggie to eliminate his problems and to essentially make the boat crash lawsuit disappear. Murdaugh denied the claim when he testified.
On June 7th, 2021, did you take this gun or any gun like it and shoot your son Paul in the chest in the feed room at your property off Moselle Road?
No, I did not.
Mr. Murdaugh, did you take this gun or any gun like it and blow your son's brains out on June 7th or any day or any time?
No, I did not.
Mr. Murdaugh, did you take a 300 blackout such as this and fire it into your wife Maggie's leg, torso, or any part of her body?
No, I did not.
Did you shoot a 300 blackout into her head, causing her death?
Mr. Griffin, I didn't shoot my wife or my son anytime. Ever.
Now, at trial, Murdaugh denied that he was in big financial trouble as well.
On June the 7th, did you believe that your financial house of cards was about to crumble?
On June the 7th?
Yes, sir.
Absolutely not.
Murdaugh was ultimately convicted, the jury finding him guilty after deliberating for less than 3 hours.
The State versus Richard Alexander Murdaugh, defendant. Indictment for murder, SC Code 16-3-0010, CDR Code 0116. Okay. Guilty verdict.
Now, the woman who read that verdict, former Colleton County Clerk of Court Becky Hill, she has caused a mountain of trouble for the prosecutors on Alex Murdaugh's murder trial. Murdaugh's team claims that Miss Becky tampered with the jury because she wanted to write a book. They asked for a new trial based on their claims that she tried to get one juror, the egg lady, kicked off the jury, and that Miss Becky made comments about Murdaugh's guilt to influence the jurors so her book would be more successful.
Well, in your book, you suggest that the guilty verdict was what you wanted, and you were fearful that that a guilty verdict would not be rendered. You say that a lot about your feeling about wanting a guilty verdict, do you not?
I do agree that that is said in the book, and part of that is because I think it was a guilty verdict.
Well, this is that you were describing a time way before the verdict was rendered when you wrote about those things in the book. Isn't that correct?
It is, yes.
And you even have something where you say that your eyes met with jurors and others at Moselle, and y'all had an understanding, unspoken, that he was guilty. You said that in the book, did you not?
I did say that in the book, and I would consider that part of the literary, the word that we just said. But there was nothing spoken with a juror at all at Moselle or anywhere else, at the courthouse or anywhere. I think that's part of that poetic license that we write to make something more apparent. But at no time did I read or try to read someone else's eyes, and that was just one of those gut feelings that I wrote in the book.
Have you heard about Upside? It's a great app that gives you cash back on things like gas, groceries, and takeout. Upside gives you real money that you can transfer from the app straight into your bank account. When I pump gas, I use Upside. I've also used it when I go out for ice cream. Here's how it works. Download the app, claim an offer for whatever you're buying, and pay as usual using a debit or credit card, and follow the steps and get paid. To find out how much you could earn, click the link in the description to download Upside or scan the QR code on your screen and use our promo code CRIMEFIX to get an extra 25 cents back on every gallon on your first tank of gas. That's promo code CRIMEFIX for an extra 25 cents back on your first gallon of gas. So Miss Becky said that was poetic license. Even a fellow clerk of court testified at a hearing for the motion for a new trial about what Hill said about a guilty verdict and book sales.
During that, before the trial, before we ever picked a jury, did she ever discuss with you that she was going to write a book?
Yes, sir. She wanted to write a book. Yes,
wanted
sir.
to write a book. Did she indicate what the book was going to be about?
About the trial?
About the Murdaugh trial?
Yes, sir.
And did she discuss with you, what if anything did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial, vis-a-vis in reference to the book? What would help the book?
A guilty verdict.
And tell the judge and me what exactly she said to you that you remember. This is prior to the trial.
Okay. Well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And then further conversations, a guilty verdict would sell more books. And we left it at that. This was before, even in December.
And when did she ever say that again to you during the week she spent there?
Several times. It could be said it was, amongst friends in her office, or we might be having dinner, that kind of stuff, but that's about it.
That she needed a guilty verdict to sell more books.
That would be the best way to sell books, yes, sir.
The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife?
Yes, sir.
Tell me what she said, and if you remember when.
I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty, and she made a comment that guilty verdict would be better for the sale of books.
But later in this hearing, Miss Becky would say something that would lead to her later being charged criminally.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
Prosecutors say that statement was a lie, and now Becky Hill faces charges of perjury and misconduct in public office related to her failed book. And while one juror testified at that hearing in 2024 that she felt pressured by Hill when she made comments about Murdaugh's guilt, Justice Toll found it wasn't enough for a new trial. Of course, Alex Murdaugh's lawyers disagree. I spoke with Dick Harpootlian back in May.
The record Justice Toll made, is pretty damn good, except we think there's federal cases that say you don't ask the juror, would it have changed the verdict or did they change the verdict? The question is, did somebody in authority say things to them that could have objectively influenced their verdict, not whether it did or didn't. She applied a state case called Green, which we would respectfully disagree with her on what it means, but it doesn't mean that. There's a federal case which says that if the record, under the record she made, which was the clerk talked to them, the clerk said things that could have influenced, we get a new trial. So, and if the state Supreme Court does not adopt that federal standard, we'll ask a federal court to hear this. But I'm convinced that we have a good opportunity here for our Supreme Court to set the boundaries on what is misconduct and what level of conduct by that clerk of court or bailiff or some court official requires a new trial. And they could give us a new trial without ever having to deal with the myriad of evidentiary issues that were raised during during the trial. And there's all kinds of issues about what we would call, as you know, technically 404 evidence, 403 evidence, expert evidence, whether they were qualified to testify or not. Our brief is well over 100 pages, and it just scratches the surface. So I'm not confident is the wrong word, but I'm optimistic that our Supreme Court will allow us to come back and give out a opportunity to defend himself on the murder charges.
Now the prosecution is pushing back hard in its brief. They say that Justice Toll made the right decision, and they're arguing against claims that Murdaugh deserves a new trial. Prosecutors write, the jury convicted appellant because he was obviously guilty, not because 3 jurors heard Becky Hill's foolish and fleeting comments about his upcoming testimony. Becky Hill's improper comments did not affect the outcome of this case. Only 2 jurors heard her unsolicited remarks to watch body language, and only 1 juror heard her comment that the day of appellant's testimony was an important or epic day. The record supports Justice Toll's finding that the verdict was solely the product of the jury's honest deliberations and reflected the overwhelming evidence of appellant's guilt. Now, remember when the prosecution introduced all of that financial crimes evidence against Alex Murdaugh at trial? It made him look really, really bad, like a terrible thief, a liar, and a fraud. And he readily admitted to being all of those things. But the state contends the jury hearing all of that evidence about the money Murdaugh stole from clients and the lies that he told was not to just dirty him up, but to show that he had a motive to kill Maggie and Paul because of the boat crash lawsuit. And the fact that he was under such significant financial stress. Prosecutors write, notwithstanding appellant's failure to appeal all the grounds upon which the trial judge's ruling was based, the trial judge properly exercised his discretion when admitting the financial crime evidence pursuant to Rule 404B and Rule 403 as evidence of appellant's motive, and his numerous limiting instructions ensured appellant could not have been improperly prejudiced by that evidence's admission under the circumstances involved. So I want to bring in an old friend to talk about the state's brief here. He is Chris Adams. He covered the Murdaugh case with me down in South Carolina, and he's a prominent defense attorney down there. So Chris, what is your response to the state's brief? I mean, this thing is this is essentially a book. It's 182 pages long, and we're not going to touch on every single little nook and cranny in it. But they're essentially pushing back, the prosecution is, and saying Alex Murdaugh does not deserve a new trial.
Right. They went point by point. So when the government responds, when the prosecution responds in a brief, they address each issue raised by the appealing party. So they addressed each issue raised by Murdaugh's legal team, and they try to knock down each one. And it's interesting in the briefing, the person who's filing the appeal, in this case Murdaugh, you get to decide which issues you really want the court to focus on by which ones you choose to go first and which ones you sort of bury further down. And they, I think through no surprise, Murdaugh attacked the behavior of the clerk of court first. Mm-hmm. And those were the first 2 issues, and those in my mind, are the meatiest issues, the toughest issues for the Supreme Court, the South Carolina Supreme Court, to wrestle with.
And I agree with you on that. Those are points 1 and 2. The whole thing having to do with Becky Hill, the former Colleton County Clerk of Court.
Now under indictment.
Yes, now under indictment. But she's not under indictment for jury tampering. And so I think that we can kind of break this down a couple of ways. She is definitely under indictment for misconduct in office. Justice Toll said she didn't think she was credible. She entirely truthful, didn't think she was entirely credible. She's been indicted for perjury. Okay, so how are we supposed to believe that she didn't tamper with this jury or have the intent to tamper with this jury? Because I know when I was down there in South Carolina covering this case, the night before the verdict, I was at the party, across from the courthouse with the media, and she was over there whooping it up, Miss Becky was, and she told somebody I trust implicitly that in her conversations with the foreperson, this deliberation was not going to go past the next day. So everybody knows she was walking around Moselle at that jury view talking to the foreperson. She knew the foreperson. It's a small town. So, I mean, come on. Like, you can say, oh, well, Justice Toll talked to the jurors and interviewed them and questioned them about this and whether it impacted their verdict. And they said no. But there's just too much smoke here, Chris.
Well, there is from my perspective. So she was prosecuted for the use of funds in office, and she is now under indictment for that. So the prosecutor who charged that case made a point of not charging her for actions related to Murdaugh, because that's a case being handled on appeal by the Attorney General. So it's not a surprise to me that they made the prosecutorial decision not to broaden the charges against the clerk of court. And for any viewers out there who don't remember, there was a special hearing that former Chief Justice Toll was appointed to preside over. She's former Chief Justice, is no longer on the Supreme Court, and she does special appointments at the Supreme Court's direction. And she's a well-respected jurist in South Carolina. Mm-hmm. And she held a hearing on the effects of whether tampering existed, whether the clerk made any improper comments to jurors, whether there was any influence. You covered that hearing. I watched the hearing. And then former Chief Justice Toll made findings that she did not presume prejudice, although she did find that the clerk of court was not believable under oath. A juror testified that she was influenced by the justice or by the clerk of court. The clerk of court made comments. It suggested the outcome to her that she thought Murdaugh was guilty, and she ultimately voted in favor of conviction. In my mind, Chief Justice Toll applied the wrong legal standard, that when a court actor, a court official, outside of the presence of the defense counsel or Mr. Murdaugh, tampers with the outcome of the case, you have to presume prejudice. That's a breakdown of the adversarial system. Chief Justice Toll did not agree with the defense argument on that.
Sure.
She said that you don't presume prejudice. And then she went on to say, if you do presume prejudice, with the state's overcome it, there's no prejudice in this case because of all the evidence. I personally disagree with that. I think when there is prejudice presumed, honestly, when there's this much prejudice has been shown already, we know it's the tip of the iceberg. We know that there's always more than when you find that much, and that she talked to 3 jurors. It's very likely and reasonable that she's made more statements to more jurors and have more influence. I just don't think the public can have confidence that the verdict returned by the jurors was based solely on the evidence and not on the clerk of court's interference with the process. And because of that, I think that's a very strong appellate argument. And I hope that the South Carolina Supreme Court really takes a close look at that issue. I'm sure they'll take a close look. I hope that they reverse the case based on the tampering, because we just can't have court officials behind the scenes putting their fingers on the scale of justice. The system doesn't work if that happens.
Chris, you mentioned the motion for a new trial, that hearing that was held in January of 2024. And Rhonda McElveen, the clerk of court for Barnwell County, she was a friend of Becky Hill. And Miss Becky brought her in to help her, with this trial. This is a huge trial of the century in South Carolina. And this was a small county where this was happening. And Rhonda McElveen gets up on the stand and says, basically, that Becky Hill said, I need a lake house and you need to retire, and a guilty verdict will help sell more books. I mean, that to me is pretty strong circumstantial evidence that Becky Hill had an ulterior motive. And you can, to me at least, if you're prancing around, back in the jury room in the hallway and saying stuff, it's a big day. And I mean, that's kind of it's like, what you're doing. I mean, you can look at that and say, she knew what she was doing. So,
and what people
you're trying to taint the well without obviously tainting the well. So if I can see that, I mean, come on, you're meddling. You are, or at least attempting to meddle, right?
Well, that's right. And it's a breakdown of the adversarial process. So we believe that we have the best justice system in the world because we have a true adversarial system, and we snatch up 12 citizens in this true form of democracy, where you get 12 citizens off the street who are supposed to hear the admissible evidence and make a decision about whether guilt has been proven beyond all reasonable doubt. And we presume that what goes on behind the scenes is kosher. And in this case, we know it wasn't kosher. We know that the clerk of court had a financial incentive to make statements and comments that suggested an outcome, and that she did make those statements. It's not illegal for her to have a book deal. It's
well, it was unethical.
It's unseemly, but it's not illegal. Those things should be disclosed. And if the parties want to raise an issue, they can raise an issue. Maybe she gets knocked out completely and then her book deal evaporates. But she can't be making comments. She had no business making comments. And everyone agrees on that. The question then becomes, so what? And the prosecutors in their brief argue, well, that doesn't have anything to do with the verdict. These were innocuous statements. They were minimal. Look at all this massive amount of evidence we had against Murdaugh. Any untampered with juror was going to convict. I just don't think it's that clear. And I think when the presumption of prejudice applies, I don't believe the state has met a burden to overcome the presumption of prejudice. So,
well, and the state, no doubt, has no interest in they do not want to do this case over again. They never want to do the case over. They took their victory lap. They tried this case, they got their conviction, and they are like, he doesn't deserve a new trial. Of course, they want Justice Toll's decision to stand. But it just seems like there's a lot there from even what we saw at the hearing for a new trial. So, I mean, you're down there in South Carolina, Chris. You are boots on the ground in the trenches, defending people each day in court. You know the dynamics of the South Carolina Supreme Court. You know, the defense is going to file a response to this. They will do that. Do you see this court, the makeup of this court right now? Do you see them giving Alex Murdaugh a new trial?
I think the oral arguments will be really telling in this case. I do believe these are legitimate issues raised by the defense, and I think the Supreme Court is going to take them seriously. As far as predicting which justice might lean which way, I want to keep my powder dry on that until oral argument. It would not be shocking to me that a majority of the court is very troubled by this and finds that the presumption of prejudice exists. I think if the presumption of prejudice were to apply, if they overruled or took a different position than former Chief Justice Toll, then Murdaugh should win a new trial. And I'll tell you, to go back, not only does the state not want to retry this, but a critical witness for the state, the star detective from the South Carolina Law Enforcement Division, Owens, recently had a murder case dismissed because of a Brady violation from the same time frame. So he's now retired. He's working as a private investigator with an insurance company or whomever. And he had critical evidence of innocence in a murder case in Berkeley County, South Carolina, that was dismissed because he failed to include, make any police reports of innocent statements made by the victim's mother, which would show that the person charged with the homicide was completely innocent. So that case was thrown out. The AG is contemplating whether to re-indict it or to appeal that ruling. But that happened within the past month. And I think Detective Owens was the key person who interviewed Murdaugh, who gathered Murdaugh's clothing from the house with a gunshot residue. He's a key witness for the state. And now, if there is a retrial, he will be a damaged witness for the state. He went from being Law Enforcement Officer of the Year to being someone with a written order questioning his integrity and honesty.
Well, and if you recall, during the trial, Jim Griffin really grilled him about his grand jury testimony in this case and some of the things that he testified to at grand jury with regard to, possible blood evidence on his T-shirt. That later turned out to not be true. That there wasn't this blood spatter evidence on Alex Murdaugh's T-shirt.
Well, that's right. He's a key witness. And he is an increasingly damaged witness.
Yikes. So when do you predict oral arguments will happen in this case?
Well, the state will do a response brief or reply brief, and then it'll be set for oral argument. There are always two tracks with courts. There's the normal track, and then there's the track on cases that everyone follows. And that I suspect will have a separate track from the normal track. So I would think that this case would be, I may be wrong on that, but I would suspect and anticipate that this case will be set for oral argument soon after the response brief is in, the reply brief is in. So I would think in the next couple of months, I anticipate oral argument before the end of the year.
Interesting. Well, we will keep an eye on it. I mean, this was a big case, and the state obviously laid out in great detail all of the evidence that they believe shows that Alex Murdaugh committed these murders. And there is a lot of evidence, a lot of evidence that ties him circumstantially to these crimes. But that's not the question here. The question is whether or not he got a fair shake. So Chris Adams, thank you so much. I appreciate your time. Thank you, Angenette. And we'll keep a close eye on this one and bring you all of the latest on Alex Murdaugh's efforts to appeal. That's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.